All right, welcome to this next session, folks. This is the update on privacy. Just to let you know what we're going to do is we're going to run the session according to its scheduled time. So it'll run, and lunch will be a bit more compressed, and then the schedule after lunch will start at its scheduled time according to the program. Hope that makes sense to you. So this is a privacy discussion update and facilitated by our Privacy Commissioner, Marie Shroff.
Okay, thank you. Okay, we're starting. Okay, well, thank you very much for coming to this session. This is actually a really timely session from our point of view, and also I congratulate the people who chose this session, because actually this is a session where you can make a difference. So just very briefly, I'll explain to you the stage we're at with privacy law reform. The Law Commission spent 5 years reviewing privacy law. It issued a report last year with a whole bunch of recommendations. That report has gone to the government, and the government issued an initial very general response which said they broadly accepted the Privacy Act recommendations in a general sense, but they said we're not going to react to the specifics until September. I think it's September of this year. So what's happening at the moment is that we have the recommendations of the Law Commission inside the belly of the policy process of government right now. And Simon Ray, who is my co-presenter here and is leader of our very small policy team in the Office of the Privacy Commissioner, will be able to feed back to the team inside Justice that's working on developing the final recommendations, which will go into a draft bill. And the Minister has promised that this bill will go into the House. Is it late? It's early next year, I think. Yes, next year. That's the promise. So, ladies and gentlemen, this is actually your opportunity to feed to us and, to discuss between yourselves what you think of the proposals of the Law Commission, and to get it into the policy process at the very moment when it's being discussed and digested and put into its final form. So, as I say, Simon Ray, leader of our policy team, is my co-presenter. What we propose to do is to take you through the main recommendations of the Law Commission. Now, this is going to be fairly tight within the sort of somewhat less than an hour that we've got. And those 5 things are mandatory breach notification, posting highly offensive material, audit powers, compliance notices, and overseas data. Now, if anybody strongly feels that they'd rather just have the whole lot of those up there and just be having a random discussion of all of them, what we propose to do is Simon and I will take turns to introduce briefly each topic, and then we'll have about 10 minutes to discuss each topic, and then we can move on to the next one. So does anyone have any strong views about that? Okay, all right. Well, if that's the case, that's what we'll do. Just to remind you briefly of what our broader context is, as opposed to the context of the stage that we're at in the law reform. Pamela did a great job, thank you Pamela, of setting it in this context of the global environment. And I think what we have to remember is that getting our law right is not just about protecting our citizens and being about getting our jurisdictional act tidy. It's also about presenting New Zealand on the wider stage and being a part of that global community, which will now be necessary to make sure that people are protected online and that all of those kinds of issues are taken care of. And in addition, that our businesses have the ability to compete internationally because our law is up to scratch. Of course, there's a lot of other things happening behind the scene, and Pamela mentioned one of them briefly, which is that global privacy regulators are starting to cooperate, and global privacy enforcement will have to become a reality. But a really important part of that is the credibility of our law to deal with harms, whoever they happen to, in terms of our New Zealand jurisdictional ability. So it's all about, of course, big data. And the fact that, it's been said over and over again, but I ought to just remind you briefly, there's just that huge power out there now to collect use, disclose, manipulate data. And the second part of that equation is that we, the people, have lost control. We actually have lost control over what's happening to our data out there. So if the people lose control, a very normal regulatory response is to give a regulator some power to protect the citizens. So that's really what we're talking about today. And the examples from the FTC, which Pamela gave us, are really an interesting one because they're taking it from the point of view of consumer protection rather than, say, from the point of view of a human rights type of approach, as is the case in Europe. So I think we'll now move to the first title, the first topic, mandatory breach notification. Well, here's my usual co-presenter. Those of you who've seen him before will know that we always use Chris Slane, our pet but not tame cartoonist, to assist. So this one is actually, I'll have to get him to update it because there's only just a few discs there, aren't there, along with the paper. So mandatory breach notification, well, as we know, perhaps all I need to say is ACC. And all of you, including Pamela, I think, will know what I mean by that. Okay, here's and I feel slightly sorry for her, a middle-level manager in ACC sitting behind a desk and she's having a bad day and maybe her kids are playing up or something, and she accidentally attaches a huge spreadsheet to an email that she sends out to a particular complainant, who then proceeds to make that known. Okay, so that has caused a lot of upset. There's a lot of people out there who are upset by that. Some of them, for example, sensitive claimants, people like that. So that's a sort of social example. A business example would be the Sony data breach, where suddenly people's credit card details, were exposed online to the level of millions, or certainly hundreds of thousands of people. So the proposal the Law Commission has made is that it should be compulsory for an organisation to tell us, the people, if they have had a data breach which puts us at risk. So that will enable us, if our credit card details, for example, are lost, to take steps to maybe change that credit card number. And there is a control on it. It doesn't mean that every single agency represented in this room would suddenly have to run around notifying absolutely every data breach. We've been able to learn from US experience here, where as it's passed through the different states and been put into place, it's become more and more refined. So we're adopting the refined model, which is the risk-based model. So what I'd like to ask you to do is to have a think about how you think this would affect the agency that you work for, or, if you prefer, how you feel about it as an individual citizen. So remember, we're really interested in your views on this one because we will feed them back. Here's a gentleman here.
Thank you. Yeah, I think it's absolutely essential because I don't think there's anything to encourage organisations to notify their the people whose information they have, whereas there are things that you can do to minimise the impact of a breach if you do it quickly. So, it's one thing to learn about it, weeks and weeks and weeks later when potentially your credit card details or otherwise have been, on paste bin for ages. Whereas if you can find out within a matter of days, then you can go to the bank and get them changed. So I think it is absolutely important. Over here.
Up there at the moment, you just have lost or stolen, but I assume that between the lines, inadvertently passed on to others.
Well, no, if it's put at risk, for example, a good example would be, for example, a university about 18 months ago accidentally put their entire student database online, but then they took it down again quickly, and the only people they had to notify were, they could track who had accessed the particular. So it's quite a refined mechanism. We've got someone over here. Oh, we've got lots of people.
I'll jump in first because I've got a mic.
Oh, he's got a mic.
100% agree it's required. ACC example is a pertinent one, though. As I understand it, the data that was released was minimal, absolutely minimal, just a name, a number, and a status. It didn't say anything about the cases or anything. So, and the media took that and turned it into a huge affair, which, you know, maybe could have been circumvented if this had happened and said, look, here's the data that we lost, and here's the impact, which is essentially pretty minimal. So, not just saying it's released, but also saying what's been released.
Yes, I mean, in the ACC case, the fact that you were a sensitive complainant was enough to be seriously damaging to some people. So you've always got to have a refined approach to these things. But thank you. Yes.
Yeah, actually, I think in the case of credit card material, because of the hassle that puts people through, I think there should be a financial penalty. I think there should be recompense.
Okay.
If I give my credit card company in good faith to a company, let's not name one, and I then end up being told that I'm going to have to go through the pain of changing that credit card number, I think there should be a penalty involved, partly to disincent them from allowing it in the first place, and also to compensate me for the actual hassle.
Yeah, that's a very good point. I mean, we'll take that on board. When we come to the other powers, you'll see that there will be room for punishing companies effectively who don't do this well. We've got someone over there someone's got the microphone here. Right.
I think you're missing out where someone willfully, with authority, has leaked or transferred information to another party outside, and that this is done purposefully, but it's done secretly, and it's done with the purpose of informing the other parties so that they have advantage. And I think that there are many cases where that situation is occurring.
Okay, well, we'll take that on board. Actually, the current way the Privacy Act works probably does allow me to pursue a person who does that, but you've got to know about it first, of course. So, you know, that's always a problem, unknown crime. Yes?
Yeah, that kind of segues nicely into what I wanted to say, and not to blur the line between security and privacy too much, but they are very different things. My question is, when we do have a secretive leak or a malicious insider dropping information out there, how are most companies going to be able to detect that? There's a very, very small handful of people in the security industry, and I know that we're pretty pushed for the amount of places that we can be and people that we can talk to. How's the average firm going to connect with those resources to see what's coming out? Because a lot of the time we're actually telling firms that they've been owned.
Yes, I mean, that's obviously an issue, and you know, my previous job was being Secretary of the Cabinet, and I know perfectly well that from that job that leak inquiries are usually fruitless. They very rarely, you know, track down the actual leaker. But I think, I mean, maybe I'm a bit Pollyanna-ish about this, but I always think that it's better to start with the positive and to make sure that your staff have really good training and that, you know, there's absolutely good security provisions in place. And I mean, I think you have to remember that, yes, of course it's going to cost companies to try and fix this kind of thing, but if you don't do it, you might end up out of business because if it happens again and again and again through, you know, some clear problem inside the organisation, then you may end up going out of business, or if in the case of a government agency, having such reputational damage that life becomes pretty impossible. Microphone,
So there
please.
are two mics already out.
Oh, okay.
Isn't the having the breach disclosure notification to be extremely refined, isn't that going to be somewhat counterproductive? Because at least some of the reason for the breach disclosure is to force companies to think about security and to be more secure. If it's very refined, they can keep hemorrhaging data and say it's not secure data, so it's not really our problem. Won't that kind of be a bit counterproductive?
I don't think so. I think there are downsides to over-notification, and that's what they discovered in the US, was you get notification fatigue, you frighten your granny, you know, because they're worried because they keep getting these notices. And also, over-notification means people just start throwing them in the bin. So I think there are other ways to deal with that problem. And look, name and shame is really important. You know, companies and government agencies definitely don't want to be named and shamed on this sort of thing. Yes.
And I agree with Commissioner Shroff on that. In the U.S., the Federal Trade Commission looks at what they call reasonable security. And surprisingly, a lot of companies that have breaches, they could easily have been prevented. For example, they'll have very weak passwords. There'll be a lowercase, weak dictionary-type password where if you've got this program, you can figure it out very quickly. And then also there's a number of companies that don't use secure socket layer encryption technology. Now, I'm not a techie, but from what I understand is that this is just pretty bare minimum. And if a company doesn't use that, then they're very, very vulnerable to attacks. So my understanding is, just the reasonable level of security can really ward off a lot of these data breaches.
Yeah, thank you.
I'd jump on top of that too. Please keep in mind as you're doing this work that most companies really struggle with this stuff. The more security you put in place, the slower development is of new products. The worse a usability experience you'll experience as a customer. There's a reason that you have this triple layer security for all your iPhone apps, for the banks and logging into their accounts. So keep it simple, keep it relatively secure, or keep the security to the right level for the task at hand.
Okay, thank you. I think we're going to have to move on to the next topic now because otherwise we won't get a look in for all of them. But I'm interested and encouraged that nobody in the room from a big company or even a small one has got up and said, no, this is ridiculous, it's over-regulation and we think it's terrible. So that was the initial reaction. It sounds like people are getting used to the idea that this is really just the way of the future. Okay, I'm going to call on Simon to introduce the next topic. Simon.
Hi, everyone. So currently, Privacy Act exempts personal information held within personal and household affairs covered in the Act. But what happens when you get exposed to name activity online? Surely that's a quite serious invasion of privacy. I feel it's an invasion of my religion. Most might be nice, but and you should have some legal rights. The Law Commission's recommended that the exemption shouldn't apply when highly offensive material is disclosed. It's also recommended that it should be illegal to disclose information that was unlawfully obtained. Now, in theory, these two powers working together would give the Commissioner the power to order the removal of highly offensive material posted online. Now, I want to know, do you guys think that this is a power the Commissioner should have? And also, given the speed at which material spreads across the internet these days, is it a workable power? Is it going to be able to be applied consistently? I got a hand up at the back already.
Kia ora, Joe Pulling. So I think there's quite a distinction to be made about the right to hold information. I think this is almost a basic human right. If you've uncovered something or you've witnessed something that's been posted and it's confidential information or it's something else, you shouldn't be suddenly a legal enemy of the state, effectively, for having seen it. It's ridiculous, and that's where a lot of this goes. And I think with the illegally obtained information clause that you were just discussing, you're dangerously teetering on the edge of getting close to that. It would be not something that I would like to see personally be in New Zealand. WikiLeaks exactly is a perfect example of this. I think what's come out of that has been tremendously beneficial for world politics and social advancement. And if we had laws which would prohibit that, effectively making Julian Assange or whoever is the person that's spearheading that a legal enemy of the state, as has happened with the US, I think it's not somewhere we want to go.
Great, that's a really interesting perspective. Now, anyone want to take that up?
I just wanted to make sure I had the context right. This is absolutely in the context of personal information. It's highly offensive information relating to the person.
Yes.
Because I have this sense, I don't particularly want to go and see Piss Christ, but it's a piece of work. It's an arbler. And I'm worried about the potential for these kinds of statements to be taken by activists as a way of clamping down on the expression of statements of art. So the context is personal information. Yes?
Yes. I think there's a really interesting point there in terms of mixed information that is a combination of personal information and perhaps information of wider interest. So that's a really interesting angle that we could explore further. Where's the microphone?
Yeah, I think in order to get a little bit wider debate on this, every time I've seen this come up, it's been portrayed in terms of that my ex putting naked pictures of me up on the internet. Now, is that all we're talking about, or that's just the easiest way of explaining it? Because it seems that people always come in and talk about just that, which I think all of us would agree that we want to stop. But, could we talk about it in terms of a little bit wider approach so that we can decide whether this is a good idea, apart from just that one situation?
Yeah, that's a great idea. I mean, has anyone got examples of, situations where they can imagine things going wrong, but other stuff getting caught up that shouldn't be?
I was imagining some examples. A public figure who is anti-gay marriage, it turns out that they've got evidence they like gay sex. That would be private. Maybe that's something that is useful to disclose. I don't know, but that seems to be the grey area for me. Revealing public figures' private data in that manner. So it applies to public figures as well as yourselves. Private information, private JPEGs of people.
It's almost like there's a public interest test involved. Down the back.
I just wanted to echo the comment before the last two about the use of the word offensive. I really think this needs to be put into the context of invasive personal information that gets disclosed publicly, because offensive can be very much a matter of opinion, and the focus here I think is intended to be on the harm that it causes to that individual, and so I think there's room for refinement that can possibly take on board some of those private facts, public figure things, like where the harm is, or is it their public interest. The other thing I also wanted to say was that a lot of platforms do have notice and takedown procedures already built in, and so there should sort of be recognition of that in this kind of a framing, so that if a company sort of gets a notice that, hey, this is an invasion of my privacy, or it's bullying or harassing or whatever, and they take it down expeditiously, that they've sort of completed the task, and then it goes back to the individual who did the harm.
I think the example that everyone talks about here of the naked pictures of you, that's already covered in the Copyright Act, specifically as something that's not permitted. Whether there's no, I don't think it's the case. It's Section 105 of the...
We're talking about fast action.
Yeah, the separate question is getting fast action on that, which may be a lot more important than whether it's something in the copyright. But the questions of whether it extends to issues of genuine public concern is something that is a little bit of a different question than the example of the private individual. One gap in New Zealand law that U.S. law is able to handle separately is there's no real right to control your image in New Zealand. The concept of right of publicity, which in U.S. law deals with a lot of these issues, is really a gap in New Zealand. So having something like this in the Privacy Act is something that would, I think, fill a gap. But the balance that keeps coming up is things that are of genuine issues of personal privacy rather than things that are of public, that are hybrid, where they also have a public interest. Example, the WikiLeaks example, whether you agree with WikiLeaks or not, and also the example of the gay politician who is making inconsistent policy statements. But the difficult balance is getting the genuine private issues that people all agree should be protected, separated from things that are really hybrid, where there's also a public dimension to them.
So, microphone over here.
I'm just a little concerned on the actual technical implementation of it. It's very difficult to remove something that's been online even for a fairly short time. And the jurisdiction, what happens if this is online in a site in Russia?
That's a very good question, and that was my thought. That's why I asked about whether it could be applied consistently. I'm really interested in that idea. I mean, obviously, and Mia spoke before, obviously a lot of sites do have that ability to take down material and take down notices, but there's always that ability for, it's got cached, it's in the Wayback Machine, can you actually stop it? Or can you stop it just enough So it still exists somewhere, for instance, on Pastebin, but who's looking at Pastebin all the time?
Well, it's a matter of how much damage has been done at that point. If it's Facebook, it's probably been on there for 2 hours, everyone's seen it.
There's a lot of talk about trying to reduce the damage and stop the damage on reputation. I haven't seen any thought on how to restore that reputation. And actually, if someone's offensive information's been put out there, what's the way that we can counter the negative with positive, and where could that credible source of that counter information come from?
That's great. So we're just about done on this. We've got time for one more over here, and then we'll have to move on.
Just on the speaker over here, as we heard in Judge Harvey's talk the other day, even if you can't affect the website in Russia, there's probably still a lot of value in saying that it should be taken down, so that as a community we're not seen to be condoning it or throwing our hands in there and saying, well, because we can't do anything about it, then we won't even have an opinion. So issuing a takedown notice or even saying that it shouldn't be up there, even if we can't take it down, there's probably still benefit in that.
Great. So some great thoughts there. Public interest, interactions with the Copyright Act, control of images, and then just around the technical stuff, and technically difficult, but maybe we should try, even if we can't succeed. So great. Thanks for that. We'll move on to.
Okay. We'll move on to audit. Yes, and I might possibly take these two together, actually, in the interest of time. So can we just flick through? So a new power will require an audit of an agency's practices and systems, and I would need to establish good reasons for that. So that's the audit power. And the cartoon, yes, let's pause on the cartoon for a minute. There you go. So this is what happens to you, if you make a big mistake. Egg on the face. Okay, and then compliance notices. These two powers really go together. So I would have a power to issue a notice to an agency requiring it to bring its practices into compliance. What that means in simple terms is that if somebody's doing something bad, I can make it good. So the reason that I'd like to take these two together, audit. Audit has been proposed by the Law Commission because of very strong representations we made that a complaint-driven model doesn't work any longer. So the Privacy Office used to work on, what complaints do we get, and then from those we would sometimes look at what the problems were and perhaps go and have a little chat with an agency, often surprisingly effective actually. But there's a couple of angles to that. One is that actually you folks out there aren't complaining enough about the things that are really important. I have to say that. Possibly because it's all below the radar. You don't understand what's going on out there on the internet, or you people maybe do, but your friends and relations don't. And so people are not complaining about the real systemic issues. So, and also, of course, the power of the technology, that's why we're here, because it is largely below the radar. So the idea is an audit power, if I can establish a reason for seeking to audit an agency, and I mean, if you just take ACC, I can't talk too much about that, but say, there's obviously reason to perhaps want to go in and audit that agency. At the moment, I have to be really invited to do that. And I was by ACC. This would give me the power to go in there, and this would be right across the public and private sectors, guys. So, don't think that this is just something about government departments. It's not. If I saw a reason to, say, audit a loyalty card scheme or a bank or an insurance company or even a technology company, I could go in there and potentially do a compulsory audit. And then comes the compliance notice. If I discover things are bad and they won't fix it, I would be able to issue a compliance notice, which would be an order to comply with good practice under the Privacy Act. So I'd like to hear, this one might be a bit more controversial, so I'd like to hear some views. Yes, we have a microphone over here.
I'm from a regulator, so these seem to be, fairly standard, low intervention regulatory responses. I think the thing about compliance notices, the potential alternative to that is enforceable undertakings. That's basically kind of the same thing, but rather than, you must comply with this, it's actually getting companies locked in, or agencies or even locked into agreeing to take certain steps within a certain period of time, or there's an automatic penalty, and those are generally, court approved. So that's a different way of looking at the same thing. They're pretty standard regulatory tools.
Yeah, well, they're probably pretty similar to what Pamela talked about with the FTC. That's a somewhat different approach again to have a sort of enforceable settlement with a company, and and inside that enforceable settlement with the company is the requirement for Google and Facebook to be audited for a period of 20 years, you see. So it's playing itself out in different ways in different jurisdictions, but the underlying ability to audit and then to get a company to comply is really at the heart of what we're talking about.
I'm just wondering if an audit power would come into effect after there had been some incident or some alleged breach, or is it a power that you're just going to have to go in anywhere and audit?
No, it is a power that is qualified to some extent. There would have to be evidence of a problem, potentially, say, a new system involving lots of personal information that, we had some evidence hadn't been properly designed. So it wouldn't necessarily have to be an ACC-type major, egg on face incident. It might be that I might get through the complaint system or through media, some indication that, an example could be a flyby scheme as being unduly intrusive or something of that nature. Or an insurance company, maybe is a life insurance company or a medical insurance company is being too intrusive about the material that they want from you before they'll pay out for your claim. So it could occur in a wide variety of circumstances, and quite often might be triggered by the media, because the media are jolly good at digging stuff up. We've got someone over here.
So I think this is a very good and important power. I think it's good to have the ability to say, no, I do actually have to look at your books and work out what's going on here. I think that's definitely worth it. I work in a field where we issue public-private key pairs, and digital certificates and keys typically come with a policy statement and a practice statement, and the practice statement almost universally conforms to a common format that says, thou shalt be audited. So there's an aspect of this that I think applies to data management as well, that it might be, if you can establish a culture that you are subject to audit, people will ultimately go to the standard auditing agencies, which means you will then have like a meta-dialogue with these people to say, are you really doing this? Are you actually checking properly their data retention behaviours and their management practices? So I think this is good. The part that worries me is, when you do go into someone, inevitably the cost issue is going to come up, and ultimately their only cost recovery recourse is to increase charges on users. And it's very easy for us all to say, value my privacy. If you charge me $5 extra, I might go to the cheaper one down the road. So I think there'll be some pain about that difference between it's never happened to me, so I don't have to care, and the, oh God, you just made me pay $5 more because they had to do this audit. But I still think it's worth doing.
Yeah, okay. Well, the way it's worked in some jurisdictions overseas is that there's a sort of demonstration effect, quite often this seems to be used pretty much as a reserve power, the two things, because the agencies begin to understand that the threat of audit and the threat of a compliance notice will make them move to improve their information handling practices and to generally be good corporate citizens. So that's... I would hope, myself personally, that these would end up being reserve powers. And at least one big bank has said to me, when I explained the compliance notice power to the senior level in the big bank, and they said, don't worry, you'll never have to use it with us. And I said, well, what do you mean? And they said, look, it's just not worth our reputation to have a compliance notice put on us by the Privacy Commissioner. So I don't think that the cost issue is such a big issue, because actually companies should be thinking about saving themselves money by having good practices and saving themselves from the reputational damage of and the ultimate loss of customers. by getting themselves into a spot of bother. I mean, occasionally there'll be genuine rogue employees or accidental happenings, but I think the public is mature enough to understand that.
Just following on from that, I'm curious, what standards would you be auditing against?
Well, we haven't even got the power yet, so I think we would have to develop, obviously, some sort of audit standards, and the Canadian Privacy Commissioner has done a whole lot of groundwork on that, and it may well be that the FTC would be able to help us with that kind of thing. So, generally speaking, as a tiny little regulatory agency in a small country, we try and not to reinvent the wheel, we try and pick up work from others. Okay, yes, we've got a person here.
Speaking from the point of view of Kiwi companies that are working online that are also working overseas, and also overseas companies that want to work online here, if you were bringing in someone to do an external audit, there are companies like Trustee that do this and fall within the US and the EU safe harbors, would you automatically recognize those types of external audits as satisfying the New Zealand privacy safe harbors if they existed?
Well, I mean, obviously I can't give an absolute ruling on that. The law hasn't even been passed yet.
Right.
But I think we would be likely to take that don't reinvent the wheel approach to things generally. If enough significant work, reliable work has already been done on something, then we'd be very likely to accept it, I would say.
Yeah, because one of the biggest barriers that I've found, or hurdles, is the cost of compliance of dealing with multiple jurisdictions, especially with the EU and the Netherlands having very low thresholds, and companies trying to figure out how are we going to comply with all three if somehow there was a safe harbor that you automatically qualified for, and you knew that you were qualifying for if you qualified for New Zealand, you also were fitting within the U.S. safe harbors, or vice versa. I know the EU may be more difficult. The other markets that the companies that I have been working with are focused on over the next 3 to 5 years are Japan and South Korea, specifically, as well as a lot of other countries in Asia. So something that permits sort of one-stop shopping is extremely, extremely helpful for Kiwi companies trying to work overseas. Another thing that has been an enormous help and cost savings for the companies that I work with is the ability to get an informal, non-binding opinion from the Commission asking, is this something that would be acceptable or not? And the ability to do that here in a phone call or a couple of emails is something that's not available in other jurisdictions like the US or the EU unless you're unless you really have access. And it saves an astonishing amount of money, time, and effort for companies that are trying to work online.
So you're saying that you found that's available here?
Yeah, it's fantastic.
Okay.
And it's you seem surprised at someone saying yes.
Yeah, well, that's me pushing the boat a little bit in terms of a regulator. I think some of Pamela's ex-colleagues at the FTC would find it a little surprising. But what I've tried to do, because of I guess my kind of bureaucratic sort of legacy in my head, is to try and make things work properly and not to get in the way of business. So, I mean, I'm surprised actually that we haven't had stronger reaction to these two powers from the kind of representatives of business here. And I'm strongly encouraged by this because I think that the way I have tended to operate the existing Privacy Act is to try and make sure that, as far as possible, we assist businesses to be compliant. And we don't just operate off a sort of a rigid bureaucratic model that says tick that box, tick that box, tick that box, and I'm going to go after you if you've done something wrong. Maybe the lack of powers in our Act compared with other countries, and we need these to become consistent with other countries, has meant that we've developed that style of operation. Who knows?
And if I could just talk a little more broadly for companies in the U.S. and overseas that New Zealand's trying to attract to do business with, who I work with, the fact that I'm able to go back to them and say, we got an answer yesterday, we just contacted the Commission immediately, they got us an answer. They're astonished that happens. And
these would be Europeans.
And honestly, no, I've gotten this reaction so many times, like, this is a great country to do business in. We want to do business in countries like that, and this is fantastic. You just saved us an enormous amount of time, effort, and money.
Well, that's extremely encouraging because, I mean, to some extent, we're proposing to do this in order to bring us into line with overseas jurisdictions, so that, people can't look at us and say, well, look, they have got, the Privacy Commissioner is completely toothless and, there's no proper protection for citizens. But it sounds like, we're actually operating in a pretty good way. And, I mean, I'm a great believer in encouragement. I can't be out there being info cop in every little, transaction that's being done. You guys have got to do it. You've got to take it on board and put it in place. Okay, so we have got I think we'll move on to the next topic, unless we've got a microphone. Yes, we have a microphone.
Yes, my question just relates to the definition of what you mean by an agency. I'm thinking of a scenario like a agency that maybe operates, like for example, an email system, where you have no control over what information is posted through it. A user puts personal information in an email. It becomes publicly available by whatever fair means or foul. Does the agency, the email system, need to comply? And if not, does it need to advise all its users that it is non-compliant so that they are aware that any information they're putting into that repository could be publicly available?
Well, that's a very detailed question, so I'll try and answer it to give you some help there. The definition of agency is very broad. Even a person can be an agency in some circumstances. And if you're, doing a business, you're supplying a service, you'll definitely be an agency. At that point, well, the question of whether you're compliant or not depends on exactly what you're doing, etc. So yes, you would need, if possible, to be compliant. And if you're knowingly non-compliant, well then, I'm not a lawyer, so I won't start giving legal opinions here, but if you're knowingly non-compliant, that could be a problem in itself. And you'd certainly want to, be advising your users that the conditions of using this particular service are such and such. But look, there's a lot of detailed stuff in there, so it's a hypothetical really, but I hope that's at least of some help. But I mean, I think the general point to take out of it for this purposes of this discussion is no, you really can't hide from this kind of thing and from the Privacy Act. The Privacy Act covers the public and the private sectors, and in some cases actions by individuals. So yes, you do need to take it on board. But look, the good news is it's mostly about common sense and good manners, actually. Have a look at the privacy principles. It's about treating people's information with respect, looking after it, not showing it to people who shouldn't see it. It's all pretty common sense stuff. So please don't be frightened of it. It's really trying to assist in putting structures and legislation in place that will make for a respectful society. Okay, so I think we'll move on to the next topic, and Simon's going to handle that one. This is our last topic, you'll be probably pleased to hear.
Right, so this is the last topic that we wanted to talk through. I'll make it quite quick. This might be a little bit brief for this one. So the Law Commission's recommended that agencies should have an express responsibility for data when it's outsourced, when it goes to another agency for storage or processing, or when you send it offshore. There currently is an obligation in the Act, but it's expressed negatively and therefore may have loopholes. Also, I'd have to point it out to you, which kind of means it's probably not very effective in terms of how it sits in the Act. It's not an express statement. But the question is, what does or should an express responsibility mean in practice? How accountable can you be in the modern information environment? If something goes wrong and your company's put data offshore, aren't you also a victim somehow? And how does that flow through? in some jurisdictions, people have explored the idea of data not being allowed to go offshore at all. It's not something that we've supported. It's not something the Law Commission's recommended, but that is one of the options. So the floor is open. Who wants to take that one on?
And this one.
Yeah, cool.
Yeah, so clearly agencies have a responsibility for information when it's onshore, correct? So this looks at trying to extend that responsibility for information offshore. So isn't it just better saying that agencies have a responsibility for information wherever it may lie? Where I see this being important is that agencies have responsibility for information they've passed to third parties. And so for me, this is really talking about when you give the information to a third party, wherever they choose to put the information, you still have responsibility for it. So it's less about whether the information is onshore or offshore. I'd be happy just to say that you have a responsibility wherever it's put, but it's more about that when you give it to a third party, you don't completely give away your responsibility.
Yeah, that's a good point, and I have to admit that I actually did these slides quite quickly, and it probably should say sent to a third agency, because I think offshore is just part of that picture. But one thing that I thought was quite interesting about that is you give it to a third agency, what about if they give it to a third agency and you get a convoluted chain and those possibilities? And if anyone's had experience with that sort of thing, it'd be good to hear from them. I think the microphone's over there somewhere.
Yeah, so my question would be, and I think it's a great goal that we're aiming for here, but my question is, how are we going to ensure that that happens? And it wouldn't be a session without mentioning the word cloud. So if you do send it off to an agency overseas and they're keeping it up on their storage, how is a country with the population of Melbourne going to say to Amazon, prove to me your security? Or a vendor, prove to me your security? A lot of them will not give that information out, and that's in my experience. And a lot of them also are unwilling to make changes required for a tiny little jurisdiction such as ours.
Yeah, that's a really good point. We're currently working on some guidance on cloud computing that we should hope to have out in the next month or so, that sort of looks at the questions you should ask from a privacy perspective when looking at cloud computing. And some of you may also be aware of the I can't remember what their new name is, what used to be the New Zealand Computer Society Cloud Code. New Zealand Institute of Information Technology Professionals, yeah. And that's got some recommended disclosures, and hopefully that sort of thing will be taken on. And a lot of jurisdictions have been looking at that environment too, and thinking about how those disclosures work and what people should say. There should be a microphone from this side. We got one. Yeah, this one here.
Yeah, obviously there's the cloud means that you don't know where the information is necessarily going, but we do know that the information is going somewhere, and it is localized in some sense in some jurisdiction, irrespective of whether you know it or not. We've heard a lot about the Trans-Pacific Partnership and how awful that could be, but oddly enough, this is an area where the TPP may actually help, at least within the limits of the 11 countries that will be signing up to it, because cross-border data flows are part of the e-commerce chapter of the TPP, and one of the areas in that is a very, very strong a negotiation going on over quite strong text to enforce this particular aspect of e-commerce. So there are some positives, it has to be said, to the TPP. Thank you.
Okay. There should be a microphone over here somewhere.
So you do have the fact that the reason why you do normally have offshore data is so that in the case you don't want to put all your eggs in one basket, if the basket catches fire, or in the case that it's dropped, we have had cases where servers in Christchurch just had to be left in the building that was practically demolished. So having an offshore data centre may initially seem like a risk, but so long as you know where that data is going and you know the security measures around that data, then that should be okay. And in the case that the data centre has lied about its security measures, and this has happened, of course, in America as well, where they've had data centres have had poor backup generators, and
when their first source of power was blown, they did shut down. So in that case, you would say that they were lying to the people who were trusting them and relied that they understood that all the power measures were being taken in place. And I guess you do have some responsibilities with the company, but it's also responsibility that we should know what the data centre is doing with that information and where they're storing it and what are the security measures in place for it.
Now, there's a really interesting idea there, I think, which is that, we might come after, your company here in New Zealand and say, hey, you lost all that data, and then you say, well, my data centre lied to me about their security. And then how do those remedies work in practice? Do you really think you could sue your data provider, and actually have some success in that regard? And that's an interesting idea, I think, to explore as well. Because there's no point us chasing people here if it's not actually fixing the problem.
I'm worried about the wording of this and how the end result gets worded. There are a lot of agencies involved when data goes from A to B, data or information. The simplest one to explain would be an ISP. How would an ISP be responsible for the data? They're just a conduit. But in the stack, there's so many different layers that are just merely conduits for data to move. A Jabber, a chat, a Skype, an email, any kind of channel that moves data. And I'd want it to be worded very clearly. So what is an agency that is responsible for data, and what is just a mere conduit that this is moving through, and I have no responsibility for what you send?
Yeah, and that's a really interesting point, because that's the change from the current legislation. The current legislation says that if you are just a conduit, then you don't have obligations. And so I think that's kind of that's a really interesting point.
Hi, Michael Snowden, one NetHui founder or pioneer of the cloud computing, one of the major supporters of the cloud conduct. My comment firstly would be, if you've got your data overseas, we had a couple of clients that come to us and it's gone, you've got no redress at all unless you're a government agency or a major organisation. The cost of litigation is simply impossible. Secondly, with respect to security, we have the Cloud Security Alliance, a STAR registry, which encourages cloud providers to put their security model up on the internet, which is freely available. We became the 9th organisation in the world to do that just this week. And more to the point, the point that I want to make is that in New Zealand we have a major problem as traditional IT companies rush to this gold digging of the cloud market. And we will see people put servers attached to the internet and run it out of their garages, and the clients, business people, will not have any idea about how that works. My view about self-assessed cloud is that if you went out of the hotel here and got in a taxi and the taxi driver said to you, don't worry, I've self-assessed my driver's license, I've self-assessed my warrant of fitness, right, that's exactly the reaction you'd expect, and that's how it's working. And I would strongly argue that we need a legislative framework, and a framework that will protect particularly small businesses. Medium and large have all due diligence, the capability, they know what questions to ask. Small businesses don't even know what questions to ask, and if they had the answers, they don't know how to interpret them. There needs to be protection for the full data cycle, from the time of engagement to the time of exit. If you have a small provider go broke and there's personal property securities on the servers and you have a GSA with the bank, the receiver comes in, has no obligation to provide that data. It could take months for a company to get their data back, and it could well be broke. Do we want to wait until 1,000 customers go broke like that, and we look at bouncers are now registered, builders are now registered, financial advisors are now registered? Why? Because there's been a litany of failures and collapses that have caused this legislative change. Do we want to do in advance of the problem, or do we want to do it after the effect of the bottom of the hill? So my suggestion all the way through the submissions for the Cloud of Conduct is that we need some form of compulsory protection for the users of cloud services. As I said right back at the beginning, if you use a cloud service where someone's white labelled it, in other words, they're taking it from, say, intermediate host exchange in the States, and you think you're buying it from your local provider, but your data's in the States, you do not know, and there's no compulsion to be told so. And if it gets lost, you've got no chance at all.
Okay. Well, I think I can hear clapping from next door, so I think we must be pretty close to time. Thank you. There's a multitude of excellent points there. But just one simple response. Don't forget that compliance notices will be a really useful way for, you would potentially be able to come to me, say, this business has got my information, I need it, for business continuity. And if necessary, I would say, okay, we'll put a compliance notice on those people. They've got to cough up now. So I can't do that at the moment. So, but there may well be other legal avenues for doing it. But I think you raised a huge number of interesting points. Thank you very much to everybody. It really was great because, you know, we will be able to feed this stuff back into our process. And I think, you know, we will be taking some notes, and hopefully it'll be available online, because I think you have actually raised some new points. So my thanks to you all for participating in the session, and I hope it was useful to you also to get a better view of what's coming down the line, we hope. Thank you.
Thanks to our presenters. Just before we go, the gentleman who suggested that we fine credit card companies, fantastic. Not just limited to privacy, I hope. We should find other reasons. Pamela, I'm not sure what time your body clock is telling you, but it's admirable that you're at all the sessions and making such a contribution. It must be tough with the jet lag, and some wonderful contributions from you as well. So don't feel left out. You now have lunch, the rest of you, and I'm out of Chupa Chups. So the next session will be starting at 5 to the hour. So we look forward to seeing you back for that. Thank you.